So I'm going to call to order the policy committee meeting for tonight. It is Tuesday, August 24th. We're starting at 6:02 p.m. My name is Roberto Rodriguez. I'm chair of the committee. We only have one member today, so instead of going around the room, I'll just introduce everyone. So committee member Jeff Irish is here tonight. The staff member who takes care of this committee is Assistant Superintendent Aaron Townsend. And we also have the superintendent, Javier Botana, logged in to the call. We are tonight, I guess I'm gonna skip over the approval of the minutes until next meeting. So we have all three members. And then we can then move on to is that okay with you, Jeff? Yeah. And then we'll move on to our business items. So the first thing we're going to do, actually, let me go over the agenda and then we'll jump right into it. So we're going to go back into KLG and just revisit whatever changes have been made after the discussion that we had last month. And then we want to kind of move along to the other set of policies that are backlogged into our work. And so we're going to get into the attendance and immunization policies today, and also our suspension and expulsion policies. And these are all mostly to update them to meet some legislative changes. And then that's all we want to do. But we definitely want to try to get an idea of the backlog and how much we have to cover, because we've spent a lot of time on KLG, and we just want to kind of have an opportunity to check in the overall workload that we have, and kind of maybe start to look forward towards the end of the season, so to speak. Come November, we usually mark that as the end of the year for the board. So having said that, I'll hand it off to Assistant Superintendent Townsend so he can update us on the law enforcement policy. Aaron, you have the floor.
Thank you, Roberto. So tonight, just this around KLG is just intended as a discussion. So again, just to be clear, I'm not proposing any kind of action tonight, but just updating on proposed changes. Since we met in June, did some, attempts at revisions based on our discussion, have also shared, done some initial sharing of this draft with a few key stakeholders. Most notably that we'll talk about is the discussions we've had with Drummond about this draft of the policy. So we'll talk about some of those, their feedback, but I also shared it with our high school administrators and, and a couple other community members, that Roberto, you had suggested. So I think we can talk about that. There wasn't substantive feedback from community members, but what you're seeing, reflects my attempts at changes based on our conversation. And then I flagged in there some of the Drummond comments. So that's really the most substantive. And my thought is, to your point about clarifying next steps in process is, out of this kind of agreeing on, or, coming to kind of conceptual agreement on next steps with KLG, that over the month of September, before our policy committee meeting on the 28th, we would share this back out for a little wider visibility. I should also share, I did share the working draft with Chief Clark. So he's received it. He'd been away a little bit, so we haven't got any feedback from him, but have a pending conversation with him as well. So a few of those kind of like key stakeholders in process, but would expect between this meeting and September 28th to share back out feedback and the status of the work with the group that we convened back in late winter to update them and have a kind of communication and share the working draft, let them know kind of our timeline and where we stand so that they can be positioned to engage moving forward. And I actually, given your comments about student board member Chung, but we have had some conversation about how her and some of the other student board reps helping to convene a student engagement for some feedback. So I think those will be important steps as we move this forward to have, some, increased, continued visibility into this work and some key feedback from some of those key stakeholder groups. So, but just into the substance of the policy, I guess I want to start with like the couple of key Drummond questions, because I think that may, where we go with that may, kind of lead us down a particular path around the other proposed changes. So let me just kind of frame my discussion with them and their two kind of overarching questions for us that I have kind of summarized and flagged in that draft. So the first one is a substantive one, but their question to me was whether the committee intended this policy to apply to students solely, right? Was it intended to govern our work and the relationship for the students within our care, or whether it was meant to be intended broadly to students, staff, and community? So that question arose because, somewhat, in how the policy books are organized, this is a K, which is part of kind of like community and visitors. And so the model policy they had provided for us, and some of which this was drawn upon, had language that indicated student, staff, and others, but then a lot of the substance of the language, right, was talking exclusively about in relationship to students. So it could go either way. The implications could be, depending on, the interest of the board, right? The committee here. It could be that we would, decide at this point, that we do want to continue to develop this as like a student-focused policy at this point. The implications of that, just from a technical perspective, is that we would likely potentially rename it and give it some new letters and would move it to policy book J. It would live under J, which that's where kind of student-facing policies primarily live. So that's, in some respects, not like the technical details of that are neither here nor there. The substantive question for us is, if we wanted it to remain in K, we could have these student-facing things, but it would imply that we need to do some work of developing some language around our expectations around interactions with students, with staff, and others, right? And providing some guidance about how we may engage law enforcement for staff or visitors, right? So that's a body of work that has not been the focus of our discussion thus far, but if we left it in K in kind of this broad version, that would be, that would kind of be the implication, right, is to add a little bit of language in that regard. So, so anyway, so that's the first question. So I could pause for a minute to just talk about that, or I could frame the second feedback question, because I don't know if, I'll frame the second feedback. Frame the second one, sorry. And then that may just make it easier. So the other major feedback, sorry, I don't know, are you guys getting feedback from me? Echo?
I'm hearing feedback on your end, so let me just, maybe I need to mute myself.
It's weird, though. I don't know why that would happen. But anyway, it's not like some other random microphone picking up my stuff. But anyway, so the other one was they felt like, appreciating where we were trying to go with the student-facing stuff. Their main kind of feedback was around that second section, which is the most substantive one, around the request for law enforcement. And, I think in some ways, was consistent with some of the feedback from the high school principals, where they had questions about the kind of enumerated list of things around which, we could or couldn't call the police and so forth. And their recommendation, as it's there, is that it feels like including that level of detail in the policy obscures the intent of delivering kind of our clear guidance around when administrators and staff should engage law enforcement. And I think, given that this is kind of a Frankenstein policy pulled from the Drummond policy, the ACLU one, some of the, kind of generative stuff that the committee's done, there's some refinement that could happen there. And I see their point about just the clarity, right? And so, as we talked about it, they're happy to help us craft some of this language, that the policy could focus on kind of just that clear guidance statements around, one, reiterating, that law enforcement, one thing I think that we've established and talked about is that law enforcement should not be involved in student discipline. Kind of the introductory paragraphs, are explicit about that, right? Student discipline is the purview of the school district and, school administrators and so forth. The second that, as we have language in there, though, I think even in like that, bullet A, it is a little hard sometimes to pull out is that, in the case of immediate threat, right, to safety, that we want to empower people to get support, right, and to call law enforcement in the cases of immediate threat. And then third, there's a category of things that may, be violations of law, right, but are not immediate threats. And that, I think the substance of our conversation had been that we may consult law enforcement, but that needed to happen through consultation with the superintendent's office. And so, their feedback was it feels like that level of clarity is lost a little bit by including all that detail. And so their suggestion was, and, this is different than where we ended, but I think given their feedback, maybe makes sense, was to then have a companion procedure that has some of those more specific details in it so that the policy is the more overarching document that clarifies those specific pieces of guidance of where we have been in our conversation about when folks should consult law enforcement, and that we would have a companion procedure that provides a little bit more of that detail, and they would help us refine some of those examples, because some of those things that was pulled from the Washington State one, some of those things are contrary to kind of Maine statute. So they'd help us refine a list of those things that we may be required to report to law enforcement, but would need to come through, but are not immediate threats, and thus would need to come through the consultation of the superintendent's office. So those were the kind of two main substances of feedback. I think beyond those, we can discuss that. And then I think the third thing for us to come back to is just the introductory language, right? That regardless, kind of the first couple paragraphs of, there's been some playing with the language there, given the last conversation. So that would be the last thing for us to settle. So.
Okay. So let's take those up, because I feel like the first question maybe is the most direct one and easier for at least the committee to take on. So the difference between the policy being specifically towards students or also including staff what really boils down to whether we, obviously that question, but then as far as action, whether we keep them in book K or they move to book J. So that'd be kind of like the administrative kind of move to take place afterwards. But for us, the decision is whether or not we intend the policies to include staff. So Jeff, if you have any thoughts or anything you want to add, I'll open it to you first.
Well, this is a new development, obviously, but I would be more inclined to keep it student-oriented. Rather than reworking what we've started. Our discussion initially with respect to law enforcement, when we had that public panel discussion, revolved around student safety, and I think it was oriented in that capacity. So I think I would lean towards having it student-oriented. I'm happy to hear comments otherwise.
Yeah, I would agree with much of what you just said, Jeff. And the conversation all along has been student oriented and student centered. My sense also is that if this is the policy for students, it also contributes to quote unquote the culture in the building. So we create kind of like an expectation. So that's in essence, what we were trying to promote from the beginning. But I would agree that in terms of the policy, in my perspective, it makes sense to have it only include students. Now, Aaron, did I miss that there was any other big consequence to that other than the obvious and the administrative move of changing the book? Javier?
I guess a question, Aaron, if that happens, do we need to have another policy that deals with law enforcement with other parties or not?
So KLG, the one that we've been working on is not a state required policy. So, broadly speaking, it's optional. I think, so that's to our discretion as to whether we feel like we need a policy. So that's subject for discussion. I think the dialogue I had with Drummond about that, I'll share is, a little bit consistent with what, Roberto, you and Jeff have said, which is that's not the issue we're confronting, and taking up, right? There are very limited use scenarios where, that has come into play, and, certainly doesn't preclude us from down the road, developing something. And there could be that in the revisiting of the visitor policy, there could be some additional language that we just insert, because if you'll remember, KI is the visitor policy, which is one of the pending set of 11 policies that we have to finalize, because when we began this discussion, we removed language from the visitor policy, which we have inserted into this draft of KLG. So stick with me, about, law enforcement coming to the school building. And so we have to finalize those revisions to the visitor policy. So it could be within that context of that policy that we add some language, right? About, mainly that's focused around, if some non-staff, non-student comes to campus and is disruptive, right? What our guidance is. That would be what we could add in the visitor policy without initiating a whole new policy. So that's one strategy, I guess, for lack of a better word, we could use to tend to that need, right? Offer some guidance, but not, complicate kind of our process necessarily.
Okay, that sounds good. And again, given the amount of additional feedback we're going to run this policy through in the future, let's just add that context when we invite other people to chime in and express that the policy wanted it to be student-centered. And then when it comes back, I'm assuming this is going to go through, like you said, the group of stakeholders. And just if those sentiments are attached to whatever we present to them, let's see what it comes back with. Let's see what the boomerang comes back with.
Okay.
Great.
So, and then, so on that, just let me clarify, and also welcome Dr. Ahmed, and Jeff and Roberto, welcoming Kate Brogan, our ombudsperson. So, they're both joining us here for a little bit, may not be able to join us for the entire evening. So, and Jake is listening in out there, Dr. Giesman too. So, but what I'm hearing is shift this work to focus on students. So I'll work with them to identify what the appropriate suggested nomenclature is and all that kind of jazz. And then create a draft of some language in the visitor policy to deal with disruptive people out, coming to campus, and what guidance might be for staff around, that we can address through the visitor policy. Does that sound?
Yeah, I think that's a good place to move to right now. Yeah.
Okay, great. Thanks.
And then the second question that you brought up is just based on the feedback, not question, but was based on the feedback that, and did I get this right? This is feedback that you got from administrators?
Well, no, administrators just had questions about the items. They weren't proposing, kind of the change that Drummond was proposing, but they had questions. Yeah, about, in some instances of cyberbullying. I may want to, consult law enforcement, right? And that was an example that Drummond flagged, right? Where we have some duty, if it's depending on the severity of it, right, to report to law enforcement. So, So the administrators had just questions about some of the items. It was Drummond that was kind of proposing the feedback that our kind of like goals of what we were trying to communicate were getting lost by including that level of detail, right, in the policy itself.
Yeah. So same thing. I'll ask Jeff if he has any response to that, and then I can share mine as well.
I share some of their confusion after reading through the policy. I did have some questions, but I assume they'll be addressed after they're properly vetted through the legal channels. Just some of them were, the $750 doesn't necessarily conform with current misdemeanor criminal statutes, I think. And when we list all these infractions under B, and then O stating that and any other misdemeanor, that's a little bit confusing to me. And I don't know how that's, I'm hoping that council can provide some clarity with respect to their concerns and mine. And I know that some of A through O were kind of adopted from the ACLU policy. Mm-hmm. And I'm trying to figure out, and I'm certainly not a scholar by any sense, but when we talk about D, for instance, on disorderly conduct and how something under that provision might differ from E. So I could see how there might be some confusion in the implementation of when we list out these specific things. So I look forward to those who are involved providing input and ultimately providing some clarification.
Thank you. So one clarifying question. Was Drummond Woodson's concern that by having this level of detail, we would lose track of the direction of the policy, or did they feel like it would put us at some sort of out of alignment with some sort of law or?
Well, I think regardless of whether the specific examples live in the policy or the procedure, typically those live in procedures for us. So regardless of where they end up, there is some kind of cleanup, truing those up, if you will, with, Maine statute that will need to happen, to, Director Irish's point. So that's work that we'll do and bring back that, this is the list that kind of conforms to our expectations or not, or to the Maine statutes. So that's one piece. This is their recommendation as policy typically doesn't have these enumerated lists. That's broader, kind of the more philosophical intent to some degree, right? Not always, but, and then some of this more illustrative stuff lives in the procedure. That was certainly the case, for example, in the student harassment discrimination policy, right? Where we had lots of kind of examples to help provide guidance in the implementation of it, but the policy itself stated clearly kind of our goals and, so forth.
We when we discussed whether or not KLG would have a procedures, we felt like it wouldn't be necessary because of the companion policies that deal with a lot of these specific areas, much like the drug and alcohol. Anyways, so I do recall that being a part that we touched up on. So I personally feel like there's a reason why we were asking for this level of detail, and I would favor it. Number one, not having a procedure so that we cover the procedures and the policies that are more specific to the situations, and that KLG does include as much detail as possible. Of course, having gone through the legal counsel checkoff. So that's kind of where I'm at. And I sense, that even if the same concerns for the level of detail were shared by staff and administrators, my sense is that we, I expected that, this is a, like you said, unusual policy in the level of detail. But I still think that this is the right way to go with this policy. Superintendent, I see your hand up.
Yeah, thank you. I guess my question is, it's not that it was not, there was any legal problem with this list. It was whether they thought that that's where it should be, or whether it should be in a procedure, right?
Right. I mean, there is some clarifying needed to be done about some of the individual items on the list, but not that there was a legal problem if we had it in the policy, or if it was the procedure. It's not problematic legally to have that kind of content in the policy, given that we cleaned it up to conform to Maine statute. But, so I think we should assume we will do that, right? They wanted us to land, they felt like they wanted us to land this before doing, before taking that step, just to know where it was going to live.
I'm sorry.
Well, just one, Roberto, just to your comment. Yes, I 100% remember that's the group's similar discussion about procedure, right? At this point, with the level of detail in the policy, right, it did feel redundant with the model procedure that they had, that was of limited value thus. And so totally remember us saying, well, okay, let's not move that forward at this point. And there's significant detail in all the others. I think the one thing, though, what they're proposing, which doesn't exist in any of those other policies, is, and so, it's just somewhat of a, style and approach and consistency kind of standpoint, is we do need to have, whether it ends up in the policy or the procedure. So it's not a question of not having this level of specificity and guidance, right? That doesn't exist in any of the others about when people should call law enforcement, right? So we do need that level of specificity. So this is in some way, what they were raising is it would be consistent with our other policies generally if the policy language spoke more broadly, and then the procedure for this, which could be relatively narrow, right, would have more of these illustrative examples under those kinds of categories, of helping to define the the immediate threat, and then the kinds of things that we may call law enforcement but needed superintendent's office review, and then the kinds of things that absolutely we should not engage law enforcement around, right? So it's not a question of whether we need that detail. It's just positionally consistent with some of our policy stuff that they were suggesting that. And I think not just about being consistent with other policies. They felt like in service of the goals as they understand it with ours, that was their recommendation, that it would, that could be helpful if we took the detail to the procedure so that we could kind of emphatically communicate kind of the guidance, the broad stroke guidance. So that was the gist of their feedback, really, I would say, is their belief was that would help us communicate kind of the goals of our policy more clearly. But that's not the only way to accomplish that, I acknowledge.
Okay, that's helpful though to understand what the feedback was, or to better understand it. Jeff, do you have any other questions or anything else you want to add? So does that feel like good feedback on that second question from the Dermot Woodson? Do you feel like?
Well, I guess this is where we're missing a third party, because I feel like you and Jeff had differing feedback. I heard Jeff's feedback feeling like it potentially made sense. We all have the feedback that we'll true it up to Maine statute, so that's clear.
Apologies for interruption. Your clarification puts us on the same track.
So the truing up to the statutes is your concern.
Yeah, your explanation I think it's put us all on track. So to the extent we need a third party that has an alternate opinion, then we can wait for another meeting or move forward to number 3. Pardon?
You can flip a coin.
No, but so what, thank you, Jeff. That's helpful. So what I'm hearing is leaving some level of this detail in the policy. We can work to refine. I think there are ways that we can refine the language to make it clearer, these distinctions that are confusing in the reread right now.
To the extent it gets shored up from council, it's fine. In the application in policy, or in procedure, I should say, as we charge the superintendent or his designee to create that, then I'm perfectly fine with that.
Okay. So I hear that as we're at this juncture going to focus on the policy and not the development of a companion procedure to whatever this one will be called.
And then we will get these trued up, the list.
Yeah, for sure. Yeah.
Yeah,
Okay.
that sounds like a good place to be.
Okay.
Excellent. So then the third area was we were going to go over the language changes to the we were calling it at one point the preamble, but it's an introductory paragraph. I don't know if it was appropriate to call it a preamble without there being a section, but this, Jeff, if you recall, the first paragraph and the second paragraph in the policy we discussed last week. So we'll see where we are at now. Aaron?
Yeah. So I mean, just to give a brief voiceover, I think there was, some desire to, as well, consistent with some of the other policies, offer a little bit of kind of rationale or, overarching framing for why we're, laying out the policy as we are. So most of the substance of that, lives in that first paragraph. There was feedback about the third paragraph, which is a proposed elimination, and that it was redundant and conflicted, with what followed in terms of requests for law enforcement. So it's proposing to just eliminate the third paragraph. So you don't see that any longer here now in the draft that was uploaded. But I'd invite feedback. I know Chair Figdor, offered some, suggestions of wording that the group could take or leave to the first paragraph as well.
I'll make a comment. I'm fine with the proposed language as revised.
Great. Same. I think I like the framing of this, and I think I talked a little bit about that last month. So this reflects what I was hoping we would achieve in that introductory paragraph. I didn't see Chair Figdor's, I got her email, but when I opened the attachment, I'm not sure I was able to identify what her suggestions were. Can you point to what those are?
Yep. So in the second sentence of the first paragraph, let me just compare versions here. She proposes, instead of cooperative, she proposes let's see, do we say this critical? Well, no, so after the opening sentence, it says, in service of developing a safe and equitable, in developing safe and equitable school communities, the district recognizes that, and this is her insertion, it is critical to establish and maintain. So that's an addition, proposed addition. And then in lieu of cooperative, a clear, well-defined relationship with law enforcement authorities that aligns with the district's equity goals while protecting students, staff, and maintaining a safe school environment and safeguarding school property.
Yeah, the one piece that I do like is the well-defined relationship in lieu of cooperative, because because I think that speaks to the purpose of the policy that has already so much detail. Yeah, my initial kind of reaction is a positive one to those additions, and then they're in line. I don't think it changes the spirit at all, but just kind of adds a little bit more. The biggest difference is just the change to cooperative, which I think it's a overly used word.
Yeah. Okay.
So we're not approving anything, but I do like those suggestions. So when they go on to the next set of eyes and stakeholder input, I think I feel comfortable with sharing those as part of the draft language. Good. And that was I'm sorry. Go ahead.
Forgive me. I just had one question, and if this is an inopportune time, then please raise your hand. But and this is just for possibly superintendent's clarification, is when we talk about in subsection C, under request for law enforcement assistance, we talk about alternatives may include, and this is again in lieu of contacting law enforcement. Do we have or have we considered the implementation, and it may already exist, and I apologize if that's already the case, but do we talk about the notification of parents, guardians, caretakers, when infractions exist? That are they part of restorative justice mediation? Is that something that already exists, or because I noticed in the proposed expulsion language that there's I think it's a statutory due process with respect to notification, and I'm not saying that needs to exist in this case, but are we taking the same approach of having parental caretaker involvement in? Because I could envision a case where someone's harassed or assaulted, for that matter, that may fall under a misdemeanor offense where they actually want to pursue privately law enforcement outside of what the school decides to do. So is that something that's that has been considered?
Two things. One, I actually think that as a matter of practice, that is, very early on in the list of interventions, what people do. So I do think that it's missing here as just probably because it's assumed that we will do that. So I think that we should, definitely include it. And, so I think that's one. And then the specifically to your question, part of due process for any form of discipline usually involves contacting the parents. So, as a matter of course, that would always happen in the case of a student who's up for discipline. It often also happens even when it is an issue of due process, and so it's the student who was affected by the circumstances that gave rise to the discipline is also contacted. So I would be comfortable with including something, and I'm not exactly sure where that would go, that is basically nothing precludes a parent from pursuing police engagement in a situation that is that is specifically ruled out as part of the school. Again, it's assumed that, we obviously have no right to prohibit a parent from saying, you stole my $749, watch, and I would like to, make a police report. So nothing, precludes us from doing that. So I would be comfortable with putting something in there that just says that.
I think it slipped my mind. My apologies. Aaron, I saw you had your hand up, so go ahead first.
Well, one, just, I think your question to me raised back to, just like, is that a core principle of like how we begin to engage, as the superintendent said, as like an early intervention. And so in policy JK, our student discipline policy that we approved back in May, it speaks to that as part of the core tenet of how we engage. The language is families should be treated as partners in the process of understanding, preventing, and resolving behavioral problems at school. So, just want to acknowledge, that's an important policy in the context of this, because I think that enumeration of strategies really is reflective of the student discipline policies that we adopted. I would have a tendency, in thinking about revising this for clarity, that, we'll see your feedback, and I don't know if this opens up a can of worms, but that placement of it, as I reread it and sit with that here, that paragraph feels not helpful for us in, just in trying to get to the clarity of like when folks should engage law enforcement, given what comes before it and precedes it, and knowing that we have a separate set of policy, JK specifically, right, that kind of prescribes, this kind of level of tiered intervention and how we work through these processes. So.
It could be something to the effect of consistent with.
I was just going to say, if we could make reference to an existing policy that carries out that practice, that would be probably helpful. And I apologize if I didn't know the exact language of existing interaction with respect to discipline and parents. The other thing is, I would assume that if we make a determination based on not pursuing something under this policy, that the district is shielded if a parent follows through in some kind of on their own, so to say, disciplinary measure. Are we shielded or absolved from, I'd say a student steals an iPhone and we are aware and we take disciplinary measures in-house to avoid interactions with law enforcement, and a parent decides to go off on their own. And I'm not a legal scholar, so would we be absolved from having known that took place? We notified the parents. Are we somehow, are we protected, I should say, if there's a pending kind of lawsuit or charges based on that action?
My general answer to that is yes. We should, I think, get, full verification of that. But, this is really referring to using it for disciplinary purposes in the school. And so, we're not, again, we'll true this up to statute so that in places where we're legally required to call the police, we will, call the police. But in those places where we don't, we won't. And it doesn't mean that somebody won't sue us, but that doesn't, mean that we have a serious liability. It just, that somebody could say, and you allowed them, you refused to make a police report, even though you knew that they had stolen the $749, iPhone. And we'll say, yes, our policy says that we don't call the police for those things.
Okay. Thank you for the clarification. And if you'll indulge just one final question and we can move on. I think the language is incident specific. Do we have, or have we entertained a subsequent violations, subsequent potential misdemeanors? Right, using the same instance, you stole a phone and then 3 days later you get into a fight, or an assault and cyberbullying or something. Are we locally going through the same process, restorative justice, etc., without consideration of a previous infraction, or are we treating each incident wholly separate?
Yeah, so what does the discipline policy say about that?
Hang on. And Jeff, I did not. I had to look up the discipline policy. I didn't have that language in my head.
I should have had the foresight to look it up myself, so I apologize for the extra work.
Not a problem.
My general sense is that the discipline policy says that
there's tiered levels.
We look at the totality of somebody's experience, and so that would say that we look at, so you did this and then you did that, and so the level of consequences from a disciplinary perspective would be different in a case where somebody, had, painted graffiti on the building and then subsequently stole, computers and things along those lines. We would treat it differently than somebody who, then we would treat it differently when they stole the computer than when they did the graffiti. Because it would be, the second situation. So but I still think that what this policy says is that we would not call the police. We would deal with the incident from a disciplinary perspective differently in those situations.
And we would defer to an existing discipline policy. Yeah. Okay. I apologize for the multiple questions, and
those are good questions.
I'm there to move on.
Language, just briefly, there's language consistent with that in JK. examining totality. So.
Thank you.
I need an updated version of JK. I still have the old one.
Yeah,
We're working on that.
Yeah, no, I know. I have it in my email. I can pull it up. Yeah, great. All right, so then we were initially talking about the preamble, and then the last thing that we wanted to cover was we deleted a third paragraph from the last month's draft. And that's the one that we felt created some confusion about using the words shall use or may. I forgot exactly which was the confusion one, but we felt like it was unnecessary, and we suggested on deleting it, and so that was also taken out. I think that was pretty straightforward. We had a pretty good discussion about that last time. You recall this, right, Jeff? Yeah. Great. So, Aaron, I think that gets us through everything that we needed to cover for KLG.
Yep.
Did we? We're at 6:47 right now. Was there anything we wanted to ask Dr. Ahmed or Kate to chime in on these policies? I want to make sure that I acknowledge that they're here, like you said.
Yep. And I know Kate's just listening, kind of joining in. I mean, welcome, Kate, if any reflections or feedback. And I know Dr. Ahmed needs to jump to Deering has a virtual open house event. So I know Dr. Giesman already has moved over there. So.
All right, Aaron. So let's move on. Then we're going to go next to the
Yep. The two. So
attendance and immunization policy.
Yep. So, and again, just to clarify, to make sure, because the intent of this is proposed to approve the proposed revisions to this. Which I think we can do, but just to clarify, with having the two members present, that the two of you voting is sufficient to take action as a committee, so that we can move these forward to the full board. So these are two policies that had not been finalized. These proposed revisions are in respect to legislative changes from the spring of 2019, but we had not yet gotten to these revisions yet in the kind of sequence of policy book reviews and so forth. But both felt important. One, the compulsory attendance, just so we had the up-to-date expectations there. And then obviously immunizations is a big topic of conversation. This is in respect specifically to the immunization law that was passed in spring 2019, was subsequently challenged, but then upheld, which essentially closed the medical exemption, or not the medical exemption, but the religious opt-out. And so the language there is strictly just to conform with current statute that Drummond's provided. Beyond one, at the end of the immunization policy, they have a suggestion around the kind of missing work piece at the very end of that policy. But otherwise, we can take them one by one. Let's talk about the attendance policy, which I believe should be relatively straightforward, and then the immunization policy, and that last one is kind of the discretionary point at this juncture.
Yeah, so let's just quickly and let's vote on these one by one, just because the attendance seems to be pretty straightforward. So Jeff, on the attendance one is JEA. Any questions or anything that you want?
No, I appreciate the header up there that indicates that the changes are as a result of statutory changes. So I've read through it, and I have no. I agree with it.
Yeah, same. This is this will get us in compliance. So I'm comfortable advancing this to the board for approval. Now, are we gonna just pass these on to the board? Just in this package, or are we going to still wait to bring like a whole book to them, or what's the plan for the board to see them next month?
Yeah, we should have said before we moved off the law enforcement policy. So I would propose that this policy, I mean, I know the immunization one has the chance to, kind of develop a different conversation, but I would propose advancing these forward on their own. We should talk about, Superintendent, we haven't discussed this, but I don't believe certainly the attendance policy, I don't believe merits a workshop by any means, right? But would think we would go through a first read, second read as just a standard business item. I would propose the same for the immunization policy just to get us current with the current state immunization law, because that's being enacted currently, right? So I would propose those go as standalone. Also, as well, with what we'll review next, the suspension and expulsion policies. We've passed the revisions. These are now, there was, June legislation that this is reflective of. So I think these go pretty much as straight business items would be my proposal. I think we are looking at, kind of September. This gets to your point, Roberto, on concluding like what's our trajectory, right? September being focused on the revised KLG, whatever that's called, and the review of the 10 other policies, and that we're looking at a significant workshop in early October, and then the second read and vote in the second meeting in October around law enforcement policies. So I think we want to advance these others in the month of September, first read, second read. And I mean, I'm happy to conduct a workshop. Certainly, I don't, I defer to the group to whether that's necessary or not.
I'll actually, in regards to whether there's a workshop or not, I'll let the superintendent and chair figure that out when they do the agenda setting for the board. I trust their judgment on that, because they'll be able to also include whatever else is on the agenda and how to manage the board's time effectively. So in terms of moving these forward, let's at least clean the policy committee's hands tonight as best as we can. So Jeff, if you're comfortable, let's at least get the attendance ones out of here. If you don't mind putting a motion on the floor. I don't know. It's always kind of like etiquette, right? Like, does the chair not put a motion on the floor?
I suggest you could.
So I'll move to advance policy JEA with the proposed language to get us to meet statutory requirements.
Seconded.
All right. We've done a really good job discussing the changes and why we're agreeing with this. So I'll move us to a vote. All those in favor, please indicate. And Jeff, we can just raise our hands. Perfect. And that's unanimous. We'll move that to the full board. And that's one window I can safely close on my computer. One down. All right. So now let's move on to immunizations. I read through this. I was just surprised initially at the amount of language that was added just to explain removing the religious beliefs or philosophical reasons. Because everything that's purple in my draft, that's new language, right? Mm-hmm. Yep. So that's a lot of words to say. I thought we would just delete something on the previous one, but clearly not. You know what I mean? Yeah, this is all fine with me, Jeff. The distance learning stuff also, is that new? Did we not do this before? Like for students that previously were not physically attending schools, like those folks that were receiving services, that was the only case that I would imagine it was happening before.
Yeah, I mean, previously pre-COVID, there were very few. I mean, we had, I don't know that we had any what would be counted as distance learning students. So, and certainly we have very, very few at this juncture as well.
So, like, I guess I was meaning like when we provide special education services to students that are enrolled in like a private school. I guess those are the ones. This doesn't apply to those ones. Yeah. All right. So, do you suspect that there will be a need to have a deeper discussion about this policy just because of the greater conversation about immunizations? taking place, or is there anything else on this particular, on the revisions that we're considering right now that needs to be discussed?
I mean, my recommendation would be we need to get our current policy in line with current statutory requirements, and then we can entertain, questions about COVID vaccination from there. I would urge us, because we're in the midst of implementation of this policy, to get it in line with that. As that would be my preference, and that if there's further deliberations about a student vaccination requirement, I mean, we're not, that's, I think, further down the road, right? We have a significant amount of our population that's not even eligible. So I would suggest that in the framing to the board and moving this forward, it's just to conform with existing law as we implement that law currently.
Yeah, I agree with that. So I'll move for the committee to advance policy JLCB with the new language to get us to comply with legislative updates.
Second.
And like I said, we've had a good, thorough discussion. So all those in favor indicate. We'll raise our hands. That's unanimous. All right. Another window safely closed. Perfect. And now you want to get us into suspensions and expulsions? Yep.
So obviously, as we've talked about, we did some change. We revised and updated these. Following our updates in June, there was a law LD 474, which is now, I guess, Public Law 275, which essentially limited the use of suspension. So to the dialogue we'd had previously, about elementary school students. So now, that's, there are significant limitations to that here that are proposed. So by and large, that's the feedback there. There are, I will call out on the suspension policy. So both, and that applies to both suspension and expulsion. The state law applied to both of those things. So there's, legislative changes that are reflective of those in both of these policies. That being said, there is, one discussion point that in the review, Ms. Huey, our attorney with Drummond now, raised a comment about the language at the beginning of the suspension policy. So that comment is in there, and her concern was around, framing it as a significant disruption, and concerns about whether that could be basis for a claim, for judicial review. Excuse me. And so she had some proposed, language in lieu of that. So that was the one non-statutory, non-required. We could leave it as is, given the process we went through previously. But she felt like since we were reviewing it, she, felt it duty to just raise that question for the committee on the suspension one. And then let's talk suspension, and then we can talk expulsion. Let's just treat one by one. She had a comment on the expulsion one as well.
Yeah. So on suspensions, Jeff, any thoughts on that feedback on this? I don't know if you have it open, but her comments are annotated in the Word document on Ms. Hughes' comments. I'm inclined to keep the language that's there, but I guess I'm saying that, acknowledging her the concern that she's raising is
So I similar to medical issues, I generally default to those who we hire to represent us in their capacity. So I'm going to default to her legal advice at this point. I would probably remove it, considering she's citing precedents on how that language might affect the policy. So I think I would entertain substituting her recommendation for existing language, but there again, we find ourselves probably needing a third person to dive through that.
Yeah, I think potentially, I think having Aura jump in here might be helpful. My sense is that this, when we say that what asserts that suspensions of any length constitute significant disruptions to a student's learning, that's more of a statement of that to me, that I guess what I'm trying to get at, I don't know what the overall value of that sentence is to the entirety of the policy. So I'm questioning, or no questioning. I'm asking just to understand, yeah, go ahead, Harry. I don't know if I'm making myself clear.
Yeah, I guess I'm thinking about the way that we've been trying to frame policies, and this is sort of lacking in that framing statement in the beginning. And I think that it could potentially benefit from having something where we speak to the fact that suspensions are, we have the definition, but we don't have like a statement of purpose. And I wonder if it wouldn't be better by having a statement of purpose that says that, the board recognizes that, there are times when suspension is suspensions are necessary because all other options have been reviewed and exhausted and found to be, so I think it says that the suspension is a sort of a sanction of last resort after all of those other options have been explored, without making a statement, which I understand Melissa's, having worked with Melissa and with, our former legal counsel on the Grant case, know that is, that is something that we don't want to be in a situation where the issue that Melissa is raising is that under current state law, a suspension by a principal is not reviewable by the court. And anything that we do that says that we recognize that a suspension is a serious matter gives someone the ability to make an argument in court that it should be reviewed by the court. I don't, I get both the intent of saying like this is a last resort and the desire to not be dragged into court every time somebody gets suspended. Now, the reality is that, we've suspended a number of people over the years, and, that's the only case where it happened, and they ultimately did not win. But, it is, but the court did say, they could review it. And that was problematic for us because it meant that we had to go to court over, the actual merits of the suspension. Something that we don't want to have to do. So I'm sensitive to what Melissa's trying to do. And I wonder if there isn't like a halfway point that is a sort of a preamble statement that talks about, we, consistent with our, discipline, our discipline policy, we have all of these tiers of intervention that should happen, but then the board recognizes that at times, suspension may be, the appropriate intervention, and after all of those other steps have been exhausted.
Yeah, I think that's really helpful, Superintendent. And what I was trying to explain that this sentence or this part of the sentence felt like an aspirational statement in the part of the policy that we're trying to get in. How do we implement it? So that's what I meant. Like it had no value to me in that place. So if having, and I think that's why I've been highlighting the importance of those preamble or introductory paragraphs, because I think it it eases the burden on the rest of the language for the policy. It makes the rest of the language of the policy easier for the board to navigate when the preamble gives us the framing. And consistency also, because we've had good experiences in recent substantive policy revisions using that approach. So I'm comfortable suggesting that we.
Yeah,
I'm sorry, go ahead.
I'd be perfectly comfortable if we could massage that language in the manner in which Superintendent just alluded to, such that I don't mind a preamble so long as it mixes in some of the recommendations. Perhaps, we wordsmith it a little bit, but yeah, I think that's a prudent approach.
So let's we'll move on. We'll keep this one around and then move to expulsions.
We could, it could also, because we'll have two opportunities for review in the first read and second read. So the committee could, take action given this direction, right? And then would have the opportunity to review that at the.
So we could pass contingent on discussions about revisions with the opportunity to clarify on the first reads.
Yeah,
I'd be comfortable with that.
Yeah, same. And I think we have a good understanding of what we mean for our people.
Yeah, I think it's easily accomplishable in sentences.
Awesome. And avoid the delay.
Just for the notes, are we saying that you're moving it forward to go to the board, but with a preamble included? Okay.
And then we're going to have the first and second read process, so that will give us hopefully sufficient time to discuss any of those changes. All right, so then I'll move then to advance policy JKD with the expectation of that additional language to be discussed at the first read.
Seconded.
All right, good. Again, very thorough explanation of that. So all those in favor indicate, and that's unanimous. Excellent. And now expulsions.
Yeah. So, let me find it here. Okay, expulsion. So again, primarily, the changes conform to, the new law. So, I'll highlight one addition to that law is making available a list of free and low-cost legal services, which must be created and updated annually by the school unit. So that's a required addition, but an interesting one. But the main kind of discretionary for the committee to consider was since we have approved these policies, the revisions to the discipline policies, the board has also approved the equity policy, in which in the equity policy, it, provides for, these broader kind of reviews of not just discipline policies, but in many manner, in a variety of manner, reviewing our outcomes, regularly to, identify areas of disproportionality and so forth. And so their recommendation here was, as opposed to having that be, that's addressed and that we could then make, cross-reference the equity policy, but potentially remove that, from the, as an item specifically within the, within this policy.
To her point, would we, and I know we probably haven't, consider it's recently passed, and it probably hasn't risen to this level. Is it presumed that we would have gone through that process prior to the recommendation for expulsion? I would assume.
Right. I think.
So is it necessary language?
So I think from my vantage point that those are, and I don't fully remember the conversation with the committee had about this, but I sort of think that that this was specific to in the course of the when somebody is being put forward for expulsion, that the board would receive as part of the recommendation, as part of the, sort of the action items, would receive a report from an independent external party that would say, I don't see this as an issue where there's racial bias, racial or other bias is, in play. So I think this is different from what the equity policies thing is, like, more broadly, that we will look at everything, through a lens of, whether there is differential application, differential treatment. And that's different from what I think this specific language was aiming at, which was sort of like, along with the videotape of the incident or whatever else, that there would also be the report from, attorney or, expert of some kind saying, like, having reviewed all of the, data that's available, then, I think it should be dealt with on its merits, as opposed to, with the backdrop of whether there was bias that went into it. I honestly, we would obviously do that ourselves, but it would be us saying to you that we think that this is not a racially biased or, motivated by animus of some kind. And, having had one incident of experience with this, been in the situation where the board didn't necessarily, not all board members agreed with our, statement. And so I think it would be helpful for us to actually have a third party, perspective that came to bear. And clearly, from my perspective, if we had that and it said, yes, there is racial bias, we wouldn't be bringing the case to you.
So we're separating the two, essentially, is we're creating an independent report based on expulsion from a third party. You wouldn't be bringing it to, you'd be bringing it to us under someone else's work, a third party's work, under that specific case.
Yeah. It forces us to get that, before we bring it to you.
Okay. Mm-hmm. And I'm sorry, Aaron, did you have something to?
No, I just wanted to clarify that last point, that it wasn't like the third party would bring it forward. It's like we're bringing forward an expulsion recommendation, and that as part of kind of that recommendation, it would include
a third party's. Yeah. Okay. Sorry. I'm fine with the language as it stands.
Yeah, I think, this policy always, every time I look and think about this policy, it happens so rarely that it kind of makes me want to look at it from a different perspective. It makes me want to approach this and give it the uniqueness that it deserves, based on how rarely it happens. So with that lens, I would sort of kind of want to keep this here, but given everything that we just explained, I'm fine with the decision to separate it. I think it's probably best on practice.
Okay. And then, are there any questions about any of, just the statutory changes or? Yeah. Okay. So the recommendation, sorry, go ahead, Roberta.
So I'll move to advance policy JKE with the proposed languages. Second, and again, really thorough discussion so far. So all those in favor, please indicate.
Before you vote, just to clarify what I'm hearing.
With the suggestion of, with the amendment of removing that last.
I thought the discussion was that we would leave that language in because of,
that was my understanding, is that we're going to leave it. And similar to your argument was such that they're so few and far between that they would probably warrant that as part of the process.
Yeah. So thanks for clarifying that. So then we did have the motion second. So all those in favor, please indicate. And we'll send that to the board as well. Thank you. All right. Is that it?
That's it. I mean, I think go ahead.
I was just going to say, do you want to give us an idea of what's coming up next and what I keep referring to it as a backlog. I don't know if that's fair to say, or simply just what is the caseload that we have in front of us?
Yeah, no, these were ones that just surfaced for me. Particularly the immunization one, knowing we were, headed towards implementation of that. I checked it, this summer and was like, there I am sure is a backlog of the overall book review process, right? For us to update. We could entertain resuming that. The only other policy that we had highlighted that we have yet to kind of begin development around that potentially could work within our calendar. So the big focus for September meeting is kind of the onslaught of the full batch of law enforcement policies. So I will work very hard to get these out with sufficient time for committee members to review well in advance. But that, that's going to be a big meeting to work through those so that we could be in a position potentially to move those forward for full board if necessary. I mean, again, these are important.
Yeah, can I interject for just a second on that point? Just so I'm aging and sometimes I just forget things. In our last minutes, I seem to recall that we had a discussion about pushing this particular law enforcement policy before we address what would be considered backlog on related policies. Am I incorrect in that? That we thought it would be prudent to shore up this one before we start hitting the backlog? Or
well, my understanding of that was, I mean, I have a similar recollection of like we've kind of put those off. That's why I didn't even put them in the packet today, right? Was because we wanted to land this. I understood that to mean, and I'm open to clarification about how we want to move this forward, but that like we needed to get the overarching policy to ensure that as we reviewed those additional ones, that they were consistent with the intent of this one.
Okay.
So
we're tracking. Yep. All right. I think we're on the same board then. I apologize for the interruption.
But however, I think Jeff brings up a good point, just to add clarity to it. We clearly the expectation was not that KLG be completely approved by the board before we moved on to the rest of them. So I think we've done enough to KLG to establish the foundation that we felt was necessary to move on to the rest of them. Right. But good place to pause and clarify.
Good to go.
Yeah. And I think we've done substantive work on those other policies, right? We spent a couple months working through those. So we do have proposed revisions for review that I think we will find will be pretty consistent with where we've landed on these others. But that's September. So we could propose the one additional one that I would like potentially to advance is JICH, which is the drug and alcohol policy, essentially. So that one feels inconsistent now with like the changes we made back to ADC, tobacco, and vaping. So that's a policy I would be interested in us, reviewing and adopting. That we have some models from South Portland and other places that have taken a kind of more substance use and abuse approach with that policy that is not currently reflected in ours. So that's the only other outstanding one out there that has been kind of in discussion as being kind of worthy of taking up. So that could follow in October. We could work towards, and I have some partners in mind, that I could get input from around that to bring forward to the policy committee meeting in October, right, for discussion and review. That I don't think it's going to be as deliberative as we've needed to be around these other significant changes that potentially could tee that up to finalize for review, discussion, and moving that through to kind of close the board calendar in November with completing that. That was the last policy on our work plan that we have yet to address.
Yeah,
Policy was that?
JICH.
I believe it's JICH.
And JICH, the current version has a lot of cross-referenced policies. So it touches, because I remember when we were doing the co-curricular policy, which is down in JLCB. I remember when cross-referenced this one, and it was like, oh wow, like this needs work. It has a very punitive kind of sense to it. So yeah, it feels to me like it's a lot of work, just this one alone. But I'm just saying that based on the amount of cross-reference policies. But I agree that I'd want to get this one up the list of priorities.
All right.
I think that would be blanket agreement. Are we squared away? If we can push through, push these through the board, is there a reason why we can't approve minutes from the beginning to get that out?
So for whatever reason, I don't know why I thought you weren't here last time, but then the moment I said that, it's reverted. So yeah, let's go ahead. Let's get the minutes approved. That way we don't have a backlog of minutes. So let me put my agenda here. I even forgot the date of it. All right, so I'll move for us to approve the minutes of the meeting of June 22nd.
Second.
All right, any questions or comments on the minutes? All right, all those in favor, please indicate. And that's unanimous as well. Thank you, Jeff, for keeping us on track. All right, Aaron, that's a lot of work to prep us for September. Hopefully, my hope is that the work on KLG and the framework that it provides eases the workload on what is already a significant caseload, right? You have a lot of policies on your desk. So hopefully we've done enough work to help you go through it easily.
Yeah, I think we are in good shape with those other policies. I think we'll give them one more review, but I think based on the work we did this spring and the proposed revisions that are already in there, I feel like those are in pretty good shape. So my focus will be revising this KLG, whatever it will be now, given our decision here, and then doing some of that student, kind of communication with stakeholders about where we stand with this work so that they can engage. And I think we should talk about and be prepared potentially for additional attendees and the role we might want to have for them, if any, right? And maybe just listening at the committee, and then the workshop will be the chance for further deliberation and public engagement.
Absolutely. I think ultimately when it gets to the full board, I would like us to get, as we've always talked, try to get as much of the word out there so that we do get input from folks. This is something that so far we've done a good job at being inclusive. We've been working on this for a while, so I think we should carry it all the way through. So yeah. Excellent. All right. So that's good. With 6 minutes to spare, I entertain a motion to adjourn.
Seconded.
Excellent. All right. And all those in favor, please indicate. Excellent. So we're adjourning at 7:25 p.m. Thank you so much, guys. Appreciate it. Good night.
Thanks.